kind of recalled the early days of my high school and middle school, wherein we had the first hour of a school with a drill, the assembly. We were all asked to stand in the line, and the physical education professor would be, a teacher would be walking with a stick in those days and would be beating us for not standing straight when they say stand attention. And I didn't know why they are so mercilessly beating us at that point. But then later we learned to follow a rule, you have to be taught, you have to be disciplined. And now the social distancing rules, the masking principles, all the requirements of this pandemic are not so difficult for the human nature, especially for the students, the educated ones, because they are already given instruction, they're already given disciplining in their lives. Unknowingly, we are all educated in various formats. Kristu Jayanti College of Law is an incarnation or a vision of an educational legacy of CMI fathers, which began in the 19th century with one visionary founder, Saint Kuriakos Elias Chavra, who started education as the only tool of transformation of the society, and who instructed and ordered, as we, the Catholic missionaries or priests, wherever there is a church that we form, we should also start a school for the downtrodden and the marginalized and the underprivileged, as well as to the people of all origin without any discrimination. Because he said, only through education you can transform the society. And we strongly believe now that the 100% literacy that we reached in the state of Kerala is a contribution by this belief and the philosophy of Saint Kuriakos Elias Chavra. And in Bangalore, we have various institutions. I remember a student in Christ and Dharmaram in the early 1990s. We started an institution some 20 kilometers away from the center of the city, and now the city has come to us. And now we are going 40 miles away. Probably that will help us to in Nelamangala, and that's where we are looking at to see whether the village can be helped by our presence. That being said, our institution is keen in our vision to enhance the student population with a holistic educational tradition. And right now, our institution, a campus with more than 8,000 students, though now because of the pandemic, we are not able to see anyone in physical format. We are fortunate to have this gracious presence of all the luminaries available today, including Justice Mohan Reddy sir, who is a very close associate of Kristu Jayanti College of Law now with the various programs that we were able to organize with, as well as today as the presence of Sri Vikas Chatrath and Trivikram. So at this point, I am taking my privilege to officially, in the name of the entire management team, to welcome primarily Honorable Mohan Reddy sir to this auspicious gathering to illumine us. And with humble hearts, I welcome you, Honorable Justice Mohan sir. And it is my pleasure and privilege to welcome both panelists of the day, Sri Vikas Chatrath, the advocate, Chatrath Law Chambers. I was going through the profile given to me because I am meeting the person for the first time. And I loved the ideology of the person who said, in vain have you acquired knowledge if you have not imparted it to others. That talks a lot about your personality and how much you believe your life as a gift to be a blessing for others. And that speaks volumes about you, sir. And with great honor, I welcome you, though virtually, to Kristu Jayanti College of Law. And respected Trivikram sir, you are practicing in major area in the criminal law, but then you're a continuous encouragement, as I learned from your profile, that your regular visits to law colleges, to moot courts as a judge and as a trial advocacy competitions, your presence to and your willingness to impart knowledge with your expertise is greatly appreciated by thousands of students and hundreds of institutions across the country. And today we are also fortunate to have you here, though virtually. We are blessed to have you, and with heartfelt gratitude, we welcome you as well to the campus. And it is my privilege to welcome all the honorable justices and advocates, because as I observed, whenever Professor Dr. Mohan Rao Bolla, our principal, is organizing an event, there is always a what do you call, a bunch of luminaries always with us, and that's where we are so fortunate. I don't want to mention the names because I'm afraid to miss maybe some of the luminaries here on the stage. So please accept my word of welcome to all of you, honorable justices and advocates, to this auspicious gathering to enlighten our little social engineers platform. We call the advocates as the social reformers or the social engineers. They are supposed to be the ones who are deciding the social responsibilities and the duties and responsibilities of the next generation, I believe. And at this point, I also wanted to mention how did this Kritruma Nyaya Vedika concept emerge, or even what are we expecting to do here. Even before the emerge of the pandemic, we were in a position to have interactions with the various luminaries, resource persons, which begins with the international judges, Supreme Court, say for example, from the Seychelles and other countries, as well as great honorable justices from the Supreme Court and the High Courts of various states, and to have an interactive sessions with our students, which began, I should say, in the Kristu Jayanti College Autonomous, wherein we have various types of programs. We have even our honorable former Vice President APJ Abdul Kalam came and visited our campus and interacted with our students when he was around, and he was able to interact with us. So from the Reserve Bank of India to the ISRO, to all the economic forums, to statistical forums, to chambers of commerce, to say like ambassadors and other political figures who would inspire the students. We were able to interact with the great resources of the country and the world in various formats. And Kristu Jayanti College of Law is a very small in our inception. It's only a 4th year of our inception, but we are able to organize more than 63, I believe, of interactive sessions so far with all the resource persons. And our students, I believe, have learned and are learning a lot through these programs. And it is, I should say at this point, I should admit the effort and the effective leadership taken through Professor Dr. Mohan Rao Bolla, who has initiated these various types of interactions, and they even named them, categorized them with various formats, Vichar Mandan to Kritruma Nyaya Vedika, Nyaya Visleshana, and Nyayacharya Deepika, and all those Sanskrit names beautifully describing the type of interaction our students would have. I'm not able to name all of them together, but then it's definitely through his leadership that we are fortunate. And so this is one of those opportunities, especially in the students becoming professionals and advocates. They need to know to do the mooting and to do the real experience of the moot court. We are fortunate to have the resource persons today as a panel discussion, as I understand, and with honor and pride, representing the management team of Kristu Jayanti family. Here we have a college autonomous, School of Management and College of Law, 3 entities here in the campus. And so representing all the team of 300 plus faculty members and all the stakeholders. Once again, welcoming you all, and wanted to express how grateful we are to you. So please be with us and enlighten our students. And once again, I gratefully acknowledge all the faculty members and parents of our students who are definitely an encouragement to us as well. And before concluding, I wanted to mention also that I'm right now attending another program and I need to exit this meeting to go and join back that meeting. So please kindly excuse us, Honorable Justice and other panel members. But once again, welcome to the campus. And I hope and pray that you all will be physically able to come and interact with us very soon. God permits, pandemic will run away, even though it has a lot of blessings in disguise as we are gathered here in this virtual format as well. Thank you and God bless you.
Very kind of you, Father.
Thank you, Father.
Thank you, Father, so much. We are happy to have Reverend Father Emmanuel PJ amongst us as well, who leads us through his leadership and encouragement at each step and constantly pushes us to be better versions of ourselves. We welcome you too, Father. As we move ahead with our program today, I would request Professor Dr. Mohan Bolla, Principal, Kristu Jayanti College of Law, to moderate today's session. And before Sir takes over, I would like to call upon our students to briefly introduce our chief guest and the panelists to our students. Firstly, I would like to call upon Megha Mary Michael, student, second year of BA LLB, to introduce the chief guest of the day to all of us.
And we recognize the gracious presence of Justice P.S. Narayana, sir. Hearty welcome to you, sir.
Namaskaram, Narayana Garki.
Namaste, namaste.
Very kind of you, sir, for the blessing.
Okay, no problem.
Yeah, please. Megha, please go ahead.
I deem it my privilege to introduce our chief guest of today's session, Honorable Mr. Justice Mohan Reddy sir. Sir was born on 6 June 1954. He enrolled as an advocate on 17 December 1977 and practiced in the High Court of Karnataka. Sir was appointed as an additional judge of the Karnataka High Court on 8 September 2003. And in the year 2004, Sir was appointed as a permanent judge of the Karnataka High Court. He served in the following positions: as an invitee member of the E-Committee of the Karnataka High Court, of the E-Committee of the Supreme Court of India, as a member of the National Court Management Systems Committee, New Delhi, as a member of the National Legal Services Authority, New Delhi, as a member of the National Judicial Academy of India, Bhopal, and is currently working as a member of the Krishna Water Tribunal. He also served as the chairman of the High Court's Computerization Committee, as well as the Judicial Process Re-Engineering Committee. Honorable Justice Sir is a former judge of the Karnataka High Court, and after serving a successful tenure of 12 years and 9 months, Honorable Sir retired in the month of June 2020. We are extremely honored to have you amongst us, sir. Thank you.
June 2016.
Okay.
June 2000.
Sorry, sir. 16, sorry.
That's okay.
Thank you, Megha. Now I would call upon Jibin Sebastian, a student, second year BBA LLB, to introduce our first panelist to the audience.
In vain have you acquired knowledge if you have not imparted it to others. I deem it a great privilege and honor to introduce the panelist of the day, Sri Vikas Chatrath. Advocate Vikas Chatrath is a fervent believer of the ideology. In vain have you acquired knowledge if you have not imparted it to others. Sir is a proficient advocate having prolonged experience of 26 years of practicing in the esteemed Punjab and Haryana High Court. It is because of his expertise in the wide array of legal arenas, Sir has been empaneled to represent the category of river authorities such as State Bank of India, Indian Railways, National Highway Authority of India, Indian Bank, and Punjab University. Sir is also the former standing counsel for the Union Territory, Chandigarh. Along with the ever-evolving legal justice system, Sir also has a comprehensive standing before various tribunals across Punjab and Haryana, including the Educational Tribunal, Consumer Courts, Real Estate Regulatory Authority, and Labour Courts. Besides being an adversarial form of litigation, Sir is an accomplished arbitrator and is also a trained mediator. With the motto of disseminating legal knowledge in a tremendous measure to binding lawyers and legal professionals, Sir is coordinating Beyond Law CLC, Chandigarh, India. It is indeed a great honor to have you amongst us, dear Sir.
Thank you, Jibin. Finally, I would like to call upon Ms. Hina Fatima, student second year BB LLB, to introduce our third panelist to the audience.
Good morning to one and all present here. I deem it my privilege to introduce to our second panelist. Our esteemed panelist, Mr. Trivikram, did his bachelor's in commerce and law and further went ahead to do his master's in business administration. Sir is a first-generation lawyer and blessed with the exposure on both ends, as a corporate, as in the field of HR, and a practicing lawyer of litigation. Sir's major area of work includes in criminal law, constitutional law, matrimonial law, and matters relating to economic offenses. Sir is also passionate about teaching and teaches law and non-law subjects to both undergraduate and postgraduate students. He regularly visits law colleges to judge moot court and trial advocacy competitions. We're extremely glad to have you amongst us, sir.
Thank you, Hina. Over to you, Principal, sir.
Hearty welcome to the galaxy of members, luminaries, especially Honorable Justice Mohan Reddy, sir, Honorable Justice P.S. Narayana, sir, my good friend Vikas Chatrath, sir, and the dynamic representative of Bar Council of Karnataka, Mr. Trivikram, and Reverend Father Emmanuel PJ, Professor Shivkumar, Professor Nageshwar Rao, various other faculty friends and advocate friends, and the most lovely students of Kristu Jayanti College of Law and various other colleges all over India. It's indeed an exciting moment for us to have Kritrima Nyaya Vedika session virtually being conducted for the first time today. This auspicious occasion could be realized with the gracious consent given by Honorable Justice Mohan Reddy, sir, who has always been a constant researcher and ready to disseminate his knowledge, and a knowledge sharing mission, we can say, besides being a fountain of justice. And Sri Vikas Chatrath, now during the pandemic, it is heartening to note that he could organize more than 300 webinar sessions on various legal aspects. From the luminaries, he has been disseminating, and I wonder as to how could he manage time. And this mission he had taken up is so adorable, and I take this opportunity to extend hearty commendations to him. And so also our young friend, Mr. Trivikram, he has been seen conducting various webinars on behalf of the Advocates Association, Bar Council of Karnataka, and in a very well designed manner, and so effectively there has been imparting of knowledge, and he is also part of that knowledge sharing mission virtually. And we are yet to meet. We were fortunate enough to meet Honorable Justice Mohan Reddy sir, but Vikas Chatrath sir and Trivikram were only seen virtually. And I also take this opportunity to recognize the valuable presence of Dr. Jayasimha. Simha, salutations. And he is our good friend, and he has been the syndicate member. He had demoted the office as a syndicate member, and he made his presence in the Karnataka State Law University in all respects, trying to be, as a perfectionist, trying to modulate the affairs there in the university. And now we have initiated, in fact, with the active support from our esteemed management, to organize innovative programs, and Kritrima Nyaya Vedika is one of such kind. And as the name indicates, it is meant for imparting mooting skills, trial advocacy skills among the students, the budding lawyers, and who should be groomed, as a matter of fact, in all respects, well equipped. When they go out, there shall be no such hesitation to start the practice and do good to the situation and justify their role as advocates. And I recall my early days of being a lecturer cum principal in charge in Rajiv Gandhi Institute of Law during 1992. I initiated to organize a model moot court in the very first month of its inception. To the criticism of my colleagues and several advocates, they are of the opinion that it is premature for you to conduct any moot court, and it should begin only at the curricular, as per the curricular scheme. That too, that was a 3 years law course, and the traditional way of approach was there, and they were wondering as to how do you fit in this kind of programs. But the answer they could get almost 2 months later, when Justice Panduranga Rao sir visited our campus, and he started appreciating the principal for conducting the model moot. And where shall we begin? That is a question. And the award objective of even Karnataka State Law University is to make professionally efficient advocates. And I felt, in fact, and I have been carrying that with me wherever I was there, organizing moots regularly and conducting orientation sessions. And I request the honorable panel members also to deliberate on this aspect also. And to start with, I request Honorable Justice Mohan Reddy sir to explain the significance of mooting, and kindly include in your deliberation as to when and where it should begin. Because other profession parallelly, the medical profession, I came to know that when the global principals and university vice chancellors meeting of the medical profession was organized, it was proposed that interning shall begin with the curricular programs. Right from the first year, there shall be that internship, and that internship in a way is reflected even in our profession. But the mooting and testing and keeping it as part of the curricular programs is confined to the final year and fag end of the career. Over to you, sir.
Thank you, Professor Garu. That's a wonderful introduction that you gave over the subject that we would want to deliberate upon. Well, to start with, you see, Father Emmanuel told us about what education was. I will just quote what Vivekananda said, almost on maybe identical terms. Vivekananda said, education is the formation of character, the strength of mind which is increased, and the sharpening of the intellect, so that one can stand on his own feet. This is exactly what Swami Vivekananda said way back, you see, some 100 years ago. Now, if we look at the adjectives that were used, it falls in place to what exactly Father Emmanuel mentioned. And it also falls in place because we too went through that process of discipline in schools. Fortunately, I had the benefit of fathers from the UK under whom I was, you see, under their tutelage, and the way the discipline was instilled in all of us. Well, if today what I am certainly because of all of them. Coming to the point that we need to start off with, when should the children from schools, from colleges, start the point of mooting? To my mind, it seems that it's not the college that is necessary to start a moot. Moot happens in your house every day. You have a dispute with your parents, you have a dispute with your siblings, you have a dispute with your friends, and so on and so forth, the relatives and everybody. So what happens? You start thinking, you start deciding what to say, what not to say. So the mooting starts at home itself. When we look at the other side of the mooting, I'm talking professionally now. Professionally, mooting should start only after research. The student must undergo what is called as research, because without research, you see, one cannot get those legal journal, the legal words. He will not be, he wouldn't have that wherewithal to become a good debater. You know, not all debaters are good, are not good mooters, nevertheless. But you see, they need to have the requisite qualification. The qualification is to learn a language. There must be a language which you will be able to communicate to the judges or whomsoever you want to convince on a point that you think is the right perception of things. So it starts at that level. When the student is in the first year or the second year, he doesn't know much about law. All that he knows is a few little things, like I must not go rash and negligent on my driving because he uses a vehicle or something like that. I must not use abusive language. These are all common things that each one of the student will have in his mind. But then we are not looking at that. We are looking at the intellect of the individual. An intellect which will make him into a professional lawyer, a professional judge, maybe a professional administrator as well, or maybe a good politician. I've seen of late some of the debates in the Rajya Sabha and the Lok Sabha. Some of them are wonderful speakers, so well articulating things. They're all debates. They're also in the form of mooting itself. A point which is well taken, which is with lot of reverence, which is put forward to ensure that the theme of what they want to say is collectively understood by the person listening. So you see, it's an innate thing that comes within every individual. We need to practice it. So law colleges, from the first year onwards, must teach these students how to research first. Because you see, by this research, there are two things that one would get. One is you can get to know what the subject is all about. Two is you can get to know how legally things work out in the field. How you can articulate yourself. On what point you need to stress and what point you need not have to stress. On what points which require your intellectual acumen to work. I say this because, you see, this whole idea of precedence. You just take out a book, you type in some of the words, keywords, and then, nowadays you get everything on the screen. And then what do? You come to court and then say, well, this is a judgment that you say it is a precedent. Now, it so happened in one of those days, one of those cases where I used to sit down as a judge, and then the first thing the lawyer would say is, I have a precedent. Now, I tell him, look here, Mr. Counsel, whoever you are, please tell me the facts. Without the facts, I don't want any precedents. Then I would have to tell him, look here, the law of precedent is no more good law, even in the UK. The UK says every case, the facts of every case, the law that is settled is dependent on those facts. So the facts are not identical in every case. It's always a mixture of this and that. So you can't have two identical cases by which you can take a judgment and say this is a precedent. No, it doesn't happen like that. The intellect in the person must start working. He must think out of the box and say, if the judges decided it this way, why should it not be decided another way as well? That is the intellect that a student must learn. The sharpness of that will ultimately pave way towards a better understanding of the law. You see, law is not static. It can never be static. Understanding of the law is also not static. It's all progressive, depending upon the facts, circumstances of the year, month, whatever day, and the situations. So one must think about how well he can overcome what has already been recorded. There may be a precedent against you, but that doesn't mean to say that you cannot make out a case. You're surely entitled to, provided you have the intellect that is working. Now, this is how the mooting starts at home. This is exactly what a child does. I am told, I was just watching the BBC the other day, and there in the medical field, they said a 6-month-old child knows which side of the bread to butter. Is it the father or the mother? What is the intellect of an individual? If a child 6 months can understand and find out whether it should be the father or the mother whom he must, butter. So see, it comes innate. It is human. So there is no need for anybody to tell them how to do things. They will understand. They will follow. They just have to put their right things together. When I say right things together, they must start with the research first. Let them understand. Let them start reading a judgment. Randomly, any judgment. Take out a judgment every day, one judgment. It can be on a murder case. It can be on a rape case. It can be on civil case. It can be a labor case, whatever. It doesn't matter. Once a lawyer is a lawyer, it doesn't matter which subject he takes up. So the reading habit, the habit to daily read something of importance is the greatest part of the start of the mooting itself. So you start culturing yourself as to what you must do. Now, this is just the beginning. Of course, I can go on and on and on. There is no end. But then this is just the beginning, as I said, research and then get into the mooting. Mooting is more about persuasiveness. You have to persuade the listener to understand your part of it. I'm sure Brother Vikas and Trivikram, they know by now how exactly a judge will view things. So it's just the persuasiveness that is necessary. And the next important thing is, don't get perturbed. Be very calm. The more calm you are, the better it is. Because the judge is always testing the skills of the person. You know why he's testing the skills? He wants to know whether he would make a good judge or whether he would make a swell lawyer. So judge also, he has an interest in the very bar association. He wants to bring up the bar association to a certain level. So he is questioning the lawyer. He wants to test his character. He wants to test whether the lawyer is likely to, be abusive. So he starts questioning you on so many things which have nothing to do with the subject itself. He might draw you away from the subject. But the thing is, the stance that you take. Are you prepared to stick on to that stance? This is exactly what mooting ultimately decides. And lastly, the presentation. One must present himself well. He must have a good dress on and then must be able to articulate well. If these things are there, which I'm sure a student of law will have, there should be no problem in starting the moot itself.
So good, sir. So good. And the fountain of justice and the rich experience. Sir says that as one of the important components is researching, and that should be the starting point. And we are going in a right direction to have a research component even introduced in the first semester itself. And to a certain extent, there is an introductory curricular components have been added in the first semester itself in the name of legal methods, wherein one of the components is research methods, and on the other hand, we have also the interpretation of statutes, and that makes a very good beginning. But as sir was rightly pointing it out, there is the beginning of mooting even at home, and even during the childhood plays, there can be some acting as a judge, and there may be somebody brought to him stating that he had stolen something, and there are some for and against arguments. Even during the children while playing, they also moot, and that is what is reflected. And we have fortunate enough to have a very good beginning in this panel discussion. And coming to the literal sense of moot is something which is debatable, something which is uncertain, something which is imitating, and we have all these things put together, and we imitate or replicate a court room in the form of a moot court hall, and we make our students to act like advocates and judges, and try to create a joy while learning things, and try to get involved in the mooting. And for that, a good beginning is made in the first year itself, and that has been the order of the day even in our Kristu Jayanti college. And now I request Vikas Chatrath sir to deal with these components of research and other issues and the methodology that has been generally followed all over the world in conducting the moot courts and mooting training, namely the ILAC, or we can even say that it can be renamed as IJAC, issues law, which includes the judgments or the precedents, and then the application of those laws to the facts and the issues which are culled out after the research that is conducted, and then the conclusions. And this methodology that is generally adopted in having these moots trained, or training that is necessary, and the methodology that is to be adopted for any mooter. Vikas sir.
Yes, sir.
First of all, I would like to congratulate Kristu Jayanti College, who has taken a good initiative. And as they say, even in a profession, they say that the best point should be put forth. And when we had Justice Ram Reddy speaking, he has hammered the right perspective. Like in a law or even in the moots, we say that the first opening statements creates the first impression as to what type of a lawyer or a student you are. Mooting, as you rightly said, I can say it's more like a shadow of what you do in the profession itself. It is akin to what, as a lawyer, when he gets into the actual courtroom, and it's more like a virtual courtroom. The moots are like a virtual courtroom, where you actually, when you enter into the real life, you are learning that. And if we actually examine why mooting should be done, it has to be kept in mind why one intends to do mooting as a student. Because mooting has its own facets, which one, with the flux of time, learns. First and the foremost is that for any mooting, it's like a teamwork. You will have to choose a good partner, because it's not like a normal court case that you take a case and you will decide it. Moots is more like a teamwork. Another partner of yours coupled with another researcher of yours. It shouldn't start off in a college that you choose X, and then you are proceeding further, you find that this researcher and your partner is not doing well. So it is just like any relationship you have to build up in the right perspective. And it's just like if you drop a baby in the water, the baby can fumble across. But for that, taking up any moot proposition, the first and the foremost thing is you have to think deep when you get that proposition. How deep you go into it, just like I will just try to correlate the moots as well as the advocacy. When you get a proposition, or if you get a client, you have to think while you're discussing with the client or while you're taking the moots, you have to discuss what ultimately the judge can take. So while doing it, you have to do a lot of research for that. You also have to create certain mentors initially, that what should be the way forward. While you create a memorial means it's just like a plate. You have to think analogically what it has to be done. After you have done, you have to share it with your friends, take a positive and constructive feedback from them as what has to be done. And you also have to think while you're taking moots, like I was talking to Professor Dr. Mohan Reddy. During our times, way back in 90s, the moots were not that big thing in. Now we have all seen that it's quite in. So you have to decide, just like your career, whether you are taking into arbitration, criminal law, civil law. But that doesn't mean that if the college is only taking one aspect, you will say, no, I will just want to excel in the arbitration. Because participating in the
I think there is some connectivity issue.
Yes, sir.
Because, sir, suddenly your Vikas, sir, shall I call Vikas, sir? I think it's okay. Now he has come. Sir, you were off for a moment, and kindly.
These are the challenges for the virtual platforms.
Okay.
Sometimes what you think, it is just like what you are prepared and you get something else.
That's correct.
So you have to be very, very composed. I just gave an example that you are prepared. While you're taking a proposition, you think it in A, B, C, D, that I will put across these 4 things in this manner of the proposition. But you will find the judge doesn't even ask A, B, C, D. He asks you E. And you say, no, I have formatted, I will answer it in A. You try your level best. The judge is, after all, a judge. He will judge you immediately. He will say, no, you first answer E. So while you do research analysis, you also have to think on those lines that you cannot, what you say, dodge the judge. You should be so thorough that not only A, B, C, D, you should know up till Z and back. Just like what they say that the expert can even hit from bullet, even if he's blindfolded. So that much precision you to have. So 3 principles would be there: practice, precision, and the procedural law you have to understand. And while you are doing sample memorials of the previous, just like what we do in the examination, you have to take the previous sample memorials, what is the thing forward. Then while you are preparing it, you have to see first, just like a petition, I will always try to correlate so that the students of law ultimately see. You have to first collate the facts in the right way. Then you have to see what is the position of law in that. Then you have to also see how clarified you have done. Don't just cut, copy, paste from anywhere, or taking something issue and just throw it out in whatever manner the question asked. You say that I will answer in only those facts. And like what Justice Reddy said, you have to be very thorough in law, because the more you read, like Mr. Reddy was saying, that you have to read a judgment daily. The reading of judgments help in 2 ways. Number one, that you try to, these are just like small dots in your life. You start connecting those dots, and the dots becomes the line. So your thought process also becomes a line in those entire processes. So once you read the judgment, in the normal, as a student of law, you will say principles of natural justice contains 2 cardinal principles. Nobody can be condemned unheard, and nobody can be judged in its own case. But despite the fact that these are the 2 cardinal principles, you will find day in, day out, lawyers speaking on principles of natural justice, judgments coming on that points. But actually, more you read, your expansive mind comes into being, and then you realize that what is the requirement of principles of natural justice to be done. I just give an illustration of principles of natural justice. It is just saying, let's assume a judge is going in a car. He finds that a person has shot someone. Though under criminal law, it's not principles of natural justice, but he can't say that I'm a high court judge. You stand convicted because I'm an eyewitness. Again, the principles of natural justice would come into being. The due process would be followed. In that case, the judge cannot be the judge in its own cause, number one. And he also has a right to defense. As they say that even if 99 people can escape, 1 innocent people could not be convicted. So those broader contours of natural justice would come into being. And I will say, I go a step further, then we'll take to Trivikram. The one purpose of that this mooting is that you are also assimilated with the atmosphere what the court can have. You are just not suddenly you go to the court, you do not even know ABCD. At least you know how to chronologically things have to be done, how the judge can ask any question. And it's not sometimes, especially in the moots, I can say, not in the courts. The lawyers and the professors will sometimes deliberately ask you, kindly explain what is Article 32, which in the ordinary court, they will not say under Constitution how it will pass or why 226 is come into being. Or I've been judging a lot of moots. Sometimes the judge will say, kindly explain me what is 302, which in the ordinary course, in the courts, they are so tight pressed with time. They will not ask the lawyer. It is presumed that is good. And don't think once the judge in a moot is asking you a particular question, he's trying to test you. He's just trying to assimilate you that any question, as they say, right from needle to an aeroplane, anything can be asked. I can just keep on going, but I'm seeing Trivikram is fully geared up to give his to these issues.
Yeah, thank you very much, sir. And as you were rightly stating, when you have prepared so thoroughly on 4 points, there will be some 5th point which may be raised. And I observed when I went to participate in the inter-university moot court competition. For the first time, I was attending there directly, and I, to my surprise, that uncontemplated or we did not think of, but the question that was raised was the preliminary objection. The particular person, the other party, he was raising that question, stating that the court does not have jurisdiction at all. And that kind of question may be amazing, a question that and you should be prepared. Therefore, what is required is that kind of thoroughness, as Vikas sir was rightly deliberating. And as a matter of fact, this ILAC method, I'll try to supplement to what Vikas sir was saying about this. And this, when we are thorough with the facts or the given moot proposition, we can relate that certain things. Say, for example, we witnessed a particular person meeting with an accident, and he was found to have been having a cell phone, which is a corollary or an inevitable menace with him, and he was found in his hand, and he was fallen there along with the other victim. Then the question would obviously be the facts, that those facts that there was an accident and there was a man found with a cell phone in his hand. The issue will be naturally whether he was negligent in driving, whether he was using the cell phone while driving. That will be the home take. And when you read and have the knowledge of the law relating to that, you can frame those issues and then look into the law or the ingredients and their application to the facts and that law, that part of law, namely the judicial precedents as declared by the superior courts, and then arrive at a particular judgment on yourself, and then try to either try to defend yourself in one way or the other. These are all the things which are expected to be done, and a thorough research is to be conducted. And now I request Trivikram sir as to how do you address the court firstly, and generally that has been now time and again coming in question, and very recently also Supreme Court, even the Chief Justice bench, they were said to have been chiding a budding lawyer for addressing them as Your Honor, and that also kindly incorporate in your deliberation, and how to go about a particular problem, say, or a moot proposition that has been given based on say Soumya murder case. Please, Trivikram sir. Trivikram sir, you are not audible. Trivikram, you are not audible. Please check once again. Am I right, Preeti? Trivikram sir, was he audible?
Yes, sir. He was not audible, sir.
No, sir. No, sir. He was
please,
not.
please.
Am I audible now?
Yes, yes, sir.
Yes, sir. Yes, sir. You are audible.
With the kind permission of His Lordship Honorable Mr. Justice Mohan Reddy, sir, I would like to start my few words. At the very outset, I would like to thank and congratulate Kristu Jayanti College of Law for organizing such a wonderful event during this lockdown. In particular, I would like to congratulate Dr. Mohan Bolla, who has been so active in taking up several initiatives, and one of this particular event also is, I am sure it is his brainchild. Thank you, sir, for this wonderful opportunity. And though I have been asked to speak about the how to address the court, before that I would like to speak about few other things. Mooting, trial advocacy, and client counseling, these three areas have to be focused by the students. Students of this era, they are highly equipped, highly skilled as compared to our days. Because what I see, with great respect to my learned colleagues, what I see is they are more equipped than us and more equipped than the practicing advocates. I am sure His Lordship would agree on this front, because they are, in terms of their communication, their research, their skills, their appearance, they are extremely outstanding, right? But few things what I see is addressing the court is one thing very important. As a officer of the court, it is our responsibility and it is our duty to show utmost courtesy and respect to the courts. And it may be any court, It may be trial court, it may be the court of first instance or till the apex court. We have to be highly courteous. And as an advocate or a student of law, we should know how to differentiate. Many times when I am judging trial advocacy competitions, when it is trial advocacy, I'm sure it would be before the trial courts, maybe a sessions court or a magistrate court. What happens is they would address the court as your lordship. I always say I'm more than happy to be addressed so when I'm sitting there as a judge for a limited period for judging that particular competition. But we should always draw that line of difference, how a district judge or a magistrate court, with utmost respect to the courts, how would we address them, and how would we addressing the high courts as well as the Honorable Supreme Court. That is one area where the students have to really concentrate, right? In our regular practice, we would address as your honor. Usually that is the practice. It may vary in other states, but with regard to Karnataka, we usually address the honorable judges of the trial courts, that is the presiding officers, as your honor, and the High Court, Honorable High Court, as well as the Supreme Court as your lordship, as my lords. This is the usual practice. Though Honorable Supreme Court has disposed of the petition where one of the advocates had filed a public interest litigation, how the court has to be addressed. A very interesting issue before the Honorable Court, but nevertheless, the court disposed of the matter, saying that it is left to the discretion of the advocate, whether you call it sir or my lords or your lordship or in any manner, but nevertheless, it has to be in a dignified manner. We have to, as advocates, as a party in person or as a law student, we should always show respect to the courts, right? And recently, of course, as Dr. Mohan Bolla rightly mentioned, we had witnessed one of the, it was before the Honorable then Chief Justice of India, a matter which was listed before his lordship, and the student inadvertently had addressed the court as your honor, and the court had made few remarks or observations. So that is an eye-opener for the students, because many times students have been very successful arguing before the honorable high courts as well as the Supreme Court, maybe in getting the answer scripts by way of right to information. What I see is, before me as a student of Vishwesvaraya Technological University, I had to pay 5,000 rupees to get a Xerox copy of the answer script that I have written. But now, by virtue of the students' effort, they had filed a public interest litigation before the Honorable Supreme Court, and you have to pay a nominal fee of ₹10. That is for the under the Right to Information Act, and if at all you pay something extra, it is only for the photocopy charges. All right, that is the power of the students. And I always say students' power is more, and the courts will be more lenient towards the students, and that is where the actual advocacy will start. Because one thing that I would like to emphasize here, though I am very small in front of other speakers and the honorable judge who has given a holistic view of how things have to be as a student, where to start, when to start, I would like to quote two things here. Two things that it always strikes my mind when I appear before his lordship is dressing skill. Though I am afraid to make this mention about this here, but with all due respect to his lordship, I would like to just in an academic perspective, I think his lordship would not, he would permit me to make such a submission here, right? His dressing skill,
dress code
or his dressing style, he's always dressed so well, all right? His language, all right, the flourish or the queen's language that his lordship used to use before the court, or all of you, for Mr. Vikas Chatrath, his lordship might be slightly new, because for the first time he would have encountered his lordship's speech. He would have definitely noticed that his lordship's language is exemplary, outstanding, and such a language is something, it is a great strength and asset for a student, as well a student or a lawyer. So the learning skill should start as a student. We should start every day, we should learn something new. As his lordship rightly quoted, that we should read some judgment, may it be useful or not. Once we are a lawyer forever. The day we stop reading something, the lawyer within us will die. So we should always be updated, otherwise we become obsolete. So we should not be giving such chances. And one thing, though it is slightly out of topic, but I would like to mention, because there are so many students logged in here, and I keep mentioning this wherever I go in the colleges as well as to my interns at my office. There's a slight change in the dress code these days. I see there's ankle socks used. I think with right at the inception stage, these things should be taken care of. An advocate is he's a officer of the court, and he should be formally dressed. All right, he should be formally dressed. This is the concern here is when they are at the liberty, though the colleges give them the leniency because they are students after all. So update themselves and to use the latest trend of dressing, but this gets carried away to the courts as well. I see a lot of students from the law schools. They are very good in terms of academically or with their knowledge or their argumentative skills, but the informal dressing is something very, it's of a great concern, because the court has its own legacy and decorum that is always maintained. That should be continued. And somewhere we give this leniency, somewhere I think those things will creep in, and somewhere that informal things would mess up, because going forward, these youngsters, when they become judge, they would also slightly take informally, and that legacy will be shaken somewhere. So that is something very important. And if I have time, I will be touching on other aspects, but I am not sure if I'm out.
We can go ahead. You please touch upon as to how to proceed with the same.
Just to add what Trivikram said, like when the students come, like he was talking about the socks. I also see sometimes when the students become lawyers, they come out with their spike hairs and spike beards and their everything dressed up, the shirt being loosened up, the shirts being folded, and they move with the coat with two fingers on as if they're just moving around in the university campus. And what he said rightly, that it's the first impression is the last impression. So the first impression, like he rightly said, that I have a first interaction with Justice Ram Reddy and Justice P.S. Narayana. That first impression is the last impression. Just like what I said, the opening statement, I would say it would rank lower than that. What is your original dress when you get up, the way you stand up, the way you poise up, the way you carry your file, the way you take out your pen, the way you, what's your body language? These are the impressions which actually stimulate, if they are in the right way, stimulate the mind of the judge. And we had Justice G.S. Singhvi, he used to say that the impression is what, that 49% case can become 51 is only on the impression what you carry. He said that that's where your nuances do count, where you carry the impression. It's not that every time you believe that it should be 2%, you should get a grace mark. It's not a grace mark. But I'm just trying to say that it gives you a flip. Let's assume the judge is something. So how you place your things, facts, how you place, as they say, any case which you have to be analytical, you have to do research. And if you give an example, it becomes much better. And while you are placing your arguments, try to cultivate the habit, even while drafting it, that these are the 6, 7, 8 issues which harp upon. Then try to chronologically bring which is the best argument next. But I'm going back, putting the hands of the clock back. That it's not necessary that which you feel.
Staggering. Now again, technical hitches hinder the progress of this session also. Mahesh sir, could you hear? Vikas sir is suddenly off, or
something which is appreciated at all. So even if you have to mention something, it once the order is dictated, you can always mention, and that could be rectified. All right, I understand the importance. There's a slightly something else is dictated, but you can always get it rectified once the order is dictated. And coming back to the moot court, yes, the common mistakes that we do is we Google, as his lordship said, once we Google, we get everything. But what we get is not complete. That we have to understand. Many times the research, we are losing the touch of the physical libraries. And especially since last 14, 15 months, I think none of us have visited any library, and we have lost the touch of reading. So first thing for a moot court, the preparation at the preparation stage, it should start with using the physical books. And many times what happens with the students is they say that I have used Rega Surya Rao book or some other ready reckoner which is available. I'm sorry, that is not the right book you should be using. All right. If you aim at the sky, you will reach at the tree. If we try to reach at the tree, then we land up nowhere. So, for example, you are it's a constitutional related moot court. What you should do is you should be using books like H.M. Sirvai or Durga Das Basu. Though sometimes it is very complicated, we don't understand. It is voluminous. Say we have about 21 volumes of constitutional law, and it runs through pages for a particular article. But we should start there, because what the effort that you put in as a law student will last forever. Once you become a lawyer, we all become lazy, and we always try to take things from Google, and we would like to simplify it. And we always have an excuse that we are overburdened with work and so many other reasons. But as a student, you don't have an excuse. So even in the bibliography, what I see is, this is something I would like to show, a moot memorial, which is prepared by a student somewhere way back in 2013. I am saving it only because of the qualitative aspect, the effort put in by those students. I would like to share this also, the soft copy of this with the principal, so it may be shared with other students. The bibliography part, when we come, so say it is a problem relating to a criminal law. All right, what they do is they just understand, they take up some IPC book, they read, they just come up with some pleadings, they say that, okay, I have done. No, that's not the way. The research has to be very systematic. You should always start your research with a bare act. All right, the learned judges would have spent considerable time as an advocate, as well as on the bench they would have spent. Still, they would check the bare act when it comes to clarification. All right, so it is always the law which is important, then the court made law. So you should always check the bare act, and especially when you are when you have taken up a problem relating to criminal law, you should always have a criminal manual handy. When we say criminal manual, IPC, CRPC, and Evidence Act, you should always carry. And as a student, when you are visiting your college, or you are visiting the courts for academic purpose, you always carry a manual, a civil manual, a criminal manual. Carry a civil procedure code, carry a criminal manual, so that whenever you are sitting in a particular court hall, you hear some provisions of law, you should make a note of it. And then you should again read this bare act, and then only it get registers here. And time and again, when you keep looking at those sections, it gets registered, and it gets memorized. And that is how we start remembering few sections. And one thing, though it is out of context and it may sound very trivial, but I would like to mention that most of us don't carry a pen or a small notebook that we can always carry in our pockets. A lawyer or a law student is a professional, and requesting somebody else for a pen looks very awkward. And on the contrary, though I mean, it may sound trivial, I think it is very important. So I'm just mentioning, please carry a pen, please carry a notebook, whether you are a law student or a lawyer. So there are circumstances where you get so many things to write down, all right, and that you can't say where what information will help you where. So these are very small things, but nevertheless, yes, it is always important to follow these basic things. And coming to to, Yes, sir.
Yes, sir. We'll go to Honorable Justice Reddy, sir, about the research and touching upon actually the case I have mentioned, Soumya murder case.
Definitely, sir. Definitely.
Namely, Govinda Swamy versus state of Kerala, which had created a sensation, and the background in which the case was so sensational was that it was a rape murder case, and within 1 year of that particular period of time, the special judge has given a judgment awarding death penalty to the accused, who happened to be a beggar, and there were certain sensational news coming to the effect that he was being sponsored by mafia underdons, etc. And even that advocate by name Sri Alur, he was being criticized for taking up such a case, and there were so many such things. And say at that particular juncture, say for example, a moot proposition has been given based on such sensational judgment at that stage. From that particular case, namely the judgment that has been delivered by the special judge awarding death penalty, as to how to research into and as to how to proceed further with respect to this. And I wish to hear from Mohan Reddy sir as to how to proceed with that kind of sensational case, that too a criminal case where there are certain facts and certain questions have been in a way one-sidedly decided by the judge, and ultimately when it has gone to the superior courts, altogether a different verdict might come. And as to how to proceed with this kind of proposition or the problem that has come to us, kindly explain, sir.
Yes, Professor. Before I go to the very mood that you have asked me to discuss about, let me just add to what Brother Vikas said. He spoke about principles of natural justice. It's a wonderful proposition in law. I, as a law student, when does this principle of natural justice does not apply? The normal clause is, when does it apply? But you got to also think of places when it is not applicable, because that is the reverse of it, the converse of it. The converse is also true. In certain circumstances, the principles of natural justice don't apply at all. I mean, there are so many judgments over it, the principles are well settled. Now, the other part of what Trivikram was saying, wonderful. He appeared before me, and I do remember many a times. You see, I have always believed in a dress code. You know why? I've always believed that as a lawyer, I am a trendsetter in the public. The public are looking at us, gazing at us. An example, an anecdote. Once I was traveling in my car. It was a one-way. And suddenly there was a lawyer coming from the opposite direction, which was not permitted. He was coming on a scooter. And I was also a lawyer, practicing lawyer. So I stopped my vehicle on my left and then got down. And since I was in my robes, in the sense I was in my coat, he saw me and perhaps must have thought another good lawyer, good Samaritan coming to his rescue, something like that. So I had to tell him, look here, look at the number of people watching both of us. They're watching at me and saying, well, this is a man who's going according to law. Whereas you, they're going to look at you and then frown at you. Why would you want to bring disgrace to this community of ours? A small community. So you see, such an important thing as a dress. If you did not wear the coat and you went on the one-way, nobody bothered. They would simply say another riffraff. But you wear a coat and then you go the wrong way. That doesn't send proper signals to the public. So we are trendsetters, and when we are trendsetters, we don't use that kind of clothes which demean ourselves and our positions. Then the other thing was, arguing. You argue a case. Some of them I have noticed while as a lawyer and as a judge, arguing to the gallery. He's not arguing a case to the judge. He wants all the onlookers to have a look at his arguments, and then if it may be flowery, may not be flowery, that's a different issue, but then he doesn't argue to the point. Trivikram was saying, you catch, analyze, get to the point. And Vikas also said, it must be analytical, and you come to the point and you press on the point. It may be A, B, C, D, and the judge may be asking E, Y, Z. That's a different issue. But you must also analyze the case, is what Vikram said, and I fully vouch for it. So arguing to the gallery is not the right thing. Then you must have command over language. If your sentences are not proper, if the right kind of adjectives are not used, you can give a totally different meaning to some things. You see, once it so happened, I'm so used to using adjectives in the court of law while I was dictating a case, dictating a judgment, somebody interjected. And then I said, look, I'm flabbergasted. I thought everybody knew the meaning of flabbergasted. But then from the other side, the desk, a very junior lawyer, he was talking to his colleague in a very loud tone. And he said, look at this judge. He's using bad words. See, you got to have presence of mind as well. So, presence of mind is such an important thing. Don't interject when the judge is looking at something or speaking something or trying to render a judgment. Like Trivikram said, wait till your opportunity comes. Mistakes may have happened in the facts that are narrated in a judgment, possibly. So you tell the judge after every case is over and say that these are the facts. Perhaps it would be advisable to change it. Nothing wrong. This is interjection. And then, you see, in the last 12 years that I was as a judge, I rarely found humor in court. There's no humor at all. Everybody fighting each other in a court of law. This lawyer arguing for and that lawyer arguing against. And I would try to bring in that humor. Otherwise, you see, it would be condescending. You would find two lawyers seriously fighting each other virtually. So I would say, okay, cool off. And I would bring in some kind of a joke just to, eliminate that process of seriousness in it. And then there is yet another thing about a senior lawyer. My senior was one, Mr. Tilak Hegde, who's no more. I happened to have framed the entire petition. It was a revision petition that was filed. Came up before Justice Putswamy, as he then was. And the first thing Justice Putswamy asked was, who has prepared this revision petition? So my senior, behind whom I was standing, suddenly turned towards me and he told the judge, here is my colleague. He said, he's my colleague. Never said my junior. Look at the culture. Look at the character in the senior. He said, here's my colleague who prepared this petition. And without batting an eyelid, it was allowed. That's a different issue. But the point is the character that one must have. One becomes a senior by virtue of his becoming a senior in the bar. But that senior too must have the same character. He must not differentiate between a junior and senior. Sometimes, you see, we learn from very raw juniors. We learn from their very innocent understanding of the laws. Even as a judge, I have many occasions found a very junior member in the bar coming out with some fantastic, wonderful statements, wonderful principles. These things happen. So our ears as a judge, we must keep it open. As also a lawyer, like Vikram was saying, you need a pen and pencil. I would carry a blue book with me. Whenever a case was being argued on a particular point, several judgments referred to, I would make a note of it. And that evening, I would go back to my chamber and then read those judgments for my own understanding of things. So what I'm trying to say is study, and read and read. Read is the mantram for a lawyer. He must have a voracious reading habit. In the sense, even by a guff of wind, if you get a piece of paper and it has some print in it, read it and then throw it. But read. Now, reading habit will always help in achieving certain eminence in not only in the way they articulate themselves in court, but also analyze a case. Now, coming to the point about this Govindswamy's case. Well, you see, the facts as it was narrated there. This girl, 22-year-old, was in the compartment, in the railway compartment, and Govindswamy is said to have abused her and tried to, his intention was to rape her. And then there was a small witness, a child, who said that this girl jumped out of the train and fell down. And this Govindswamy also follows and then picks her up, though she's bruised and she's badly broken her bones. And then in a sitting position, he tries to rape her. Having done his whatever has to be done, he walks away with her mobile phone. These are, I mean, broadly speaking, these are the facts. That's it. Now, the trial court convicted him both for rape and murder, because she died after 4 days in the hospital. Now, when the matter came up to the Supreme Court, you see, there was a clear understanding of these facts. They said, look, his entire intention was only to rape. So the intent was not to commit murder, but the intent was to commit the act of rape, for which he was rightly punished. And the punishment and the sentencing as far as rape was concerned was well taken. But the Supreme Court said, when there was no intent established that he wanted to kill her, the question of murder under 302 did not arise. Yes, this is one way of looking at it. Nothing wrong. Because the law, the criminal law makes it absolute. You must prove beyond doubt. That is the concept of criminal proceedings. So if there is no proof of intention to commit murder, the question did not arise. Therefore, that was the fallacy of the trial court in coming to that conclusion. Of course, you see, Trivikram and Vikas may have a different view about it. It's always open. It's open to have views. Nothing wrong. You can criticize a judgment, but you can't criticize a judge. That's it. That's the only distinction. You have every right to criticize a judge. So, if you think out of the box, is it possible to connect the fact that a bruised lady, when propped up to commit the act of rape, would have caused her eventual death? Could you put all those things together like the trial court did and say, well, you must commit him for murder? Could you say that? Is it possible? Then how do we give up the word intention which is in the statute? The statute requires the proof of intention, malice, intention. Now, if you don't come across that in any part of the evidence that is marshaled in the inquiry before the court, then how do you establish? Then what happens is you are inferring. There is no chance of inferring. One can never infer in a criminal proceeding. But one can infer on the basis of proved facts. Now, if proved facts were not available, the inference drawn was not justiciable. Therefore, the Supreme Court said, you cannot convict this man for murder. Yes, you can convict him for an act of rape because there was enough evidence. But the argument was, look here, my lord, here is a man who props that broken lady and commits the act of rape. Is that not sufficient to establish murder because she dies later on? That did not sound to reason at all, because the law is there. The law comes to his rescue. So therefore, we must try to read between lines, read above it, read below it, Read the very context of the law by itself before you can put forth a theory. For this, there is no need for precedents. It is unnecessary. The facts are all there. See, the judgment must be rendered based on the proved facts. So therefore, I strongly feel that the 3-judge bench of the Supreme Court, of which the Chief Justice, Justice Gogoi, was on the bench, rightly found that the conviction for murder was not right. Of course, with Trivikram and Vikas as well, to say something about it.
Yeah, please. And those points, suppose say, had you been defending the case and trying to bring those points together and try to have the conviction, how to go about, and what are those things which could be read in between the lines? And there was, in fact, criticism by Justice Markanday Kadzu that the Supreme Court did not even go into the actual other ingredients of of section 300, whereby knowledge of the particular accused, that the particular victim is likely to die if she was left even in that supine condition. Say he had not only raped, but she was left in a supine condition. Her belongings, including the money and cell phone, were robbed, and for that also there was a conviction. And that if she was in such a condition that she could not even mourn, and those who have come to her rescue, they could only notice her after the lapse of so much of time, and ultimately that had led to the death of it. And therefore, what could be the take home when there were some such adverse circumstances, and if you are representing the prosecution, how do you take that matter forward? I request Trivikram as well as Vikas Chatrath sir to dwell upon these points.
It is always the prosecution first, so let Mr. Vikas Chatrath deal with it. So
Right.
then comes the role of the defense lawyer. So
Okay. Sir Vikas sir, you are the prosecutor now, and be the visual Nikam in this case, and how do you take things forward? Assuming that you have moved an appeal from the High Court and to the Supreme Court.
Since we were not discussing about the moots part, I will just simplicity say that first, like what Justice Ram Reddy said, that first we have to see the ingredients of any particular section to be taken up. So once we have to see that whether those ingredients are made out, and then we'll also eventually see, after examining the evidence which has been laid on the file, as to how the things have to be taken up, and whether, like they all say that once it is an appeal, the scope is limited. You will also have to examine that as to whether there is a misreading of evidence or there is a misappreciation of the evidence, in what context. So since I would, it's my particular take, that if we take this particular session, I would only simplicity say that since we are basically playing as to what is the art of mooting, I would basically say what I stated therein, that first see that the ingredients which are required for a particular section in which we are trying to say, that's 376, 300, whether those ingredients are made out and how the law has developed into it. And if we correlate and collate the facts, two things would be very material as to how do you correlate with that particular judgments and precedents. Like we are all talking of that the precedents should not be taken into consideration. Precedents can be taken into consideration as to how, like Justice Ram Reddy said, that you have to read a lot. Once you read a lot, then maybe a particular section like an exception clause or this particular clause, you are not able to put it across. In that particular sense, sometimes your mind does not develop in that particular manner. If we read the judgment, then we can see, and if we correlate with the particular facts, a reading would be there. So you will have to demonstrate before this in a submission, while you are going in an appeal, that firstly, these ingredients are not made up. Secondly, you will have to demonstrate and establish that the evidence which has been read, as even in civil law, we say that sometimes it's not even a question of law when we say it's a misappreciation of evidence, and you as a lawyer can convince that yes, there has been a misappreciation of evidence to the said extent, like what Mr. Karju has said, that it has not been appreciated in that particular manner. So those submissions can be put forth to state therein that there is a total misappreciation of evidence, total misstating of the facts. Sometimes it is just like, I will take an example of, just to demonstrate. We had in disproportionate assets, whether that 10% could be construed as a disproportionate asset or not. But if it is running into crores, whether it is actually a misappreciation of evidence, so that subtle difference you can't, as in law we say, you can't put one size shoe which fits all. You will have to demonstrate and establish to the effect that, I will again, since we are just like his submissions, like what Mr. Reddy said, that the precedents are not statutes. So one particular fact can change the entire gamut. Like I again put back myself on the principles of natural justice. Like what Mr. Reddy said, that principles of natural justice is not a straitjacket formula. It's also a doctrine of useless formality. Way back in Jagmohan 81 Supreme Court, there are a large number of precedents which says that even if principles of natural justice have to be followed, then in that eventuality you have to show that the result would be the same. It is just like I have to demonstrate that sun rises in the east. So even if I've given a show cause notice, even if I am not given a show cause notice, the fact will continue to remain the same. So in the same way, if you read the judgment, for that matter, any matter, if we go by it, because whenever there is a judgment, you will find that the judge, while giving the reasonings for that, it's a rare judgment where you will find that there is no precedent cited in that particular judgment. But if you actually sometimes go through those judgments, you sometimes find that a particular para has been picked up, which substantiates that. But if you go deep, as they say in the law, that you have to dive deep into it. And once you dive deep into it, then you can actually come out with a difference. Like we have seen that two judges, Justice Gogoi giving a particular flip to that particular aspect, and Justice Karju going to the different. Both Supreme Court judges, they say that all judges are same except for the master of the rostrum. So that thought process for with the same particular facts, you get different. And that is what the jurisprudence has also evolved. So I won't rely as such on those principles. Trivikram can say to that extent. But my endeavor in this entire process is that what is the art of mooting? Why one should go for the mooting? Why as a lawyer? Because I feel the students can always read those judgments. But why mooting? I take a step further. Why mooting is required? Is it simply developing a law of knowledge? I was talking to a few friends of mine and their children. I said, why you have gone for the mooting? They said, sir, it also improves your networking. Let's assume there's a case in the south. How do I know it? Now these are virtual platforms. He says that I had gone to the Bangalore to do a moots. I got 4 people connected down there. I got a networking. I have got a case law out there. Skill of arguing is not an argument which you develop yourself. I can also absorb. Law is nothing but absorption and absorbing. I may learn something from Trivikram as a lawyer in the art of mooting. I may, Justice Reddy is after all a judge, but I can learn nuances from Mr. Reddy, how he's hammering his point in a subtle manner, or how he's an expressive. So that absorption, this mooting also helps you. It's not your skill. While you listen to the other speaker, maybe he's an opponent to you. You can learn that nuances. And the more you practice, then there's more of self-confidence. Self-confidence, like Mr. Reddy said, that also comes by knowledge. We all know that it's empty vessels make more noise. Like he said, arguing for the gallery and content is always, if this vessel is full of water, it will not make noise, but it has something to cherish upon. So knowledge for a particular aspect has to be done. And for moots, it's also a court mannerism. A judge, maybe I have gone for mooting, or like Trivikram said that I have gone for a mooting. He will judge something. I asked him, what is Article 141? He says, sir, this is not at all relevant. Article 141, you also know it. That is an offensive way. One way could be, no, Article 141 says it has those powers of constitution. But if we apply 141 in these particular facts, and sometimes you may not even know the facts, but in your art of advocacy, like it's just like in skills of an interview, you can take the judge gradually to the point which you are actually fully prepared and take him to that. And moots also help to employability. Let's assume you have gone and you have argued well. A person says that, why don't you join my office?
Okay.
That's how. And I will ask Trivikram that teamwork, again, we said that it has to be done. The failures and success in the moots, sometimes you feel that you are very good. In law, you learn that sometimes your best cases, even in the moots, you are lost. Sometimes they ask you to give a feedback. But this is a sports event. It's like a sports. Sometimes you lose, sometimes you win. You learn that sometimes it's not suddenly you go to the court and you find that your good case has been lost. But since you have done moots, you have learned that art, you learn how to live with that. I will ask Trivikram to take things forward.
Yeah, before Trivikram goes into that aspect, actually he is asked to deal with the defense. The prosecution side as it is the pertinent question that has been raised in this particular case, which we have touched upon, is that because the court was asking, where is the evidence that he had pushed her down? And that makes a lot of difference. And the court was in fact not appreciating the fact, though the circumstantial evidence put forth, that she was hit to the rail compartment and he was hit to a hard, flat substance. And even assuming that is not, there is no direct evidence possibly available. Even if it is taken granted that she had jumped out of the train to save herself from that particular person who was attempting to commit rape. And that is one aspect. The responsibility can be vested on or shifted to that particular person to disprove his liability. And another is that the court in fact did not appreciate the ingredients of or other ingredients that are there under section 300. That is what could have been taken up further by the prosecution if it goes in appeal to the next court. Now I call upon Trivikram to deal with the defense as to how to put forth the defense points in this particular case.
Definitely, sir. So when we take up a criminal case, it is always the burden of proving beyond reasonable doubt. Always it is on the shoulders of the prosecution. Most of the case, as we all know, in our country, the conviction rate is hardly less than 3%. And I would not touch upon the reason why the conviction rate is very less. It may be in terms of a faulty investigation, or many other reasons could be perhaps the reason for low conviction rate. But here what we are touching upon is the defense points. So I would like to say the prosecution should establish their case at the first rate. May it be before the trial court or subsequently before the first appellate court or before the apex court. It is always the trial, the way the trial has conducted, the questions posed by the defense lawyer to the witnesses would mainly determine the case even at the appellate stage. Here, as honorable judge and my esteemed colleague, my esteemed learned friend, Mr. Vikas Chatrath mentioned, it is the ingredients. When a particular offense for a particular section has not been made out, it would be very difficult for the court to convict accused, what happens is there are certain ingredients as per IPC, as all of us know. If those ingredients are not made out, then it would be difficult for the courts as well. Though the courts are mentally inclined to convict the accused, but there are no substantial evidences. So as a defense lawyer, what happens is, few things that we have to consider is the prosecution would have, it is on their shoulders to establish a case with the chain of events, completing the chain of events. But the role of the defense lawyer is very simple. You break the chain everywhere, maybe at the trial stage, maybe at the appellate stage. So even in this case, when we say as a fact and as a principle established under the criminal jurisprudence, as we all know, actus non facet reum nisi mens et rea. So two things what is important is, first there should be an act and there should be the mental intention. Here in the present case also, what the court in its wisdom has observed or acquitted Govind Swami from the charges of murder, that is section 302 of IPC, because there was no mental intention. His mental intention could have been perhaps only to rape her or to get some kind of sexual satisfaction by doing a particular act. But it is very clear from the facts as well as perhaps the evidence placed before the Honorable Supreme Court that he had no mental intention of murdering Soumya. So that is one thing that we have to understand. If there is only act, for example, it's a wrong example, but pardon me. Suppose I imagine somebody killing somebody. There's a mental intention, but there is no act. Then it doesn't constitute an offense. So to constitute an offense, there should be two things. One is act, actus reus, and second one is mens rea. Without the mental intention, no criminal offense will be attracted. It will not make out a criminal case. So therefore, and second thing is, there are two views. On the 3 judges bench headed by the then Honorable Chief Justice has acquitted, and he has a different view. And one of the former Supreme Court judges, Justice Kajju, had a different view. That is the wisdom of the court. All right. There's always a perspective. The way I look at things might be different, and we cannot compel. That is the wisdom of the court. And in the wisdom of the court felt that the case was not made out. When the case itself has not been made out, it would be infringing the rights of the accused. Accused also has certain rights, and that rights, till the court is convinced, court cannot award such a penalty. The heinous the offenses, the court has to be more vigilant in awarding serious punishments. So I think that would suffice.
So good. And the points made out are that there ought to be breaking of the chain by the defense, always being thorough and trying to find out the loopholes from the points of the prosecution, and the prosecution must have been proving the case beyond reasonable doubt.
This reverse burden, except in the case of reverse burden, in few cases like POCSO, where the burden is directly on the accused, most of the IPC cases, the burden is on the complainant or the prosecution.
That's good. That's good. And Vikas sir, there may be a situation where, say, there is a case decided by the High Court of Kerala in a case popularly figured as Agnes, wherein the right to residence of the daughter-in-law was in question before the High Court. Justice Bhavadasan was confronted with a situation that there is no law to the effect that there will be a right, and the court in such a situation where there is no law, how to take home or put forth the argument and proceed with respect to whatever we have. We have only the sympathy on the particular person, and what could come to your rescue when you are arguing on behalf of that poor lady with a small girl. She was driven out of the matrimonial home, stating that you have no right and I am the real owner, and it has been a burden for me to look after you besides a mad son in that particular case? In such a situation, how to put forth the argument, and what do you suggest to the students of law when there is such a case where there is no law?
That's what I'm saying. The more you study, then you develop your mental faculties in a different manner.
Yes.
Two aspects where there are vacuums, we have a lot of judgments to that effect, where there is even vacuum in law. So law to that effect is, if we, let's assume hypothetically that Trivikram is to oppose, they say that the courts will not legislate. But there are judgments to the effect. Vishakha is a classic case wherein there were judgments, there were directions issued to the effect. Like we had in our High Court, there was an issue where the lady had conceived, she had been raped, and she had conceived. Whether that medical terminacy should be given or the child had a right. So it requires more and more of study as to what are the conventions, what are the international conventions, what are the law commission reports to that effect. If you, sometimes you have to buttress your submission with the help of facts, sometimes by precedents, and sometimes by the recommendations and the research which has been done. Sometimes those research help you where they say that you hit the right point in the mind of the judge that this issue requires development. And there have been certain cases where the judge have also issued directions to the effect that the court, that the legislature on the legislative type should examine the matters. We have seen Honorable Supreme Court issuing directions under the Motor Vehicle Act, Motor Accident Claims Tribunal cases, to the effect where they find that there is a vacuum. So the courts normally interpret the statutes, but sometimes where there is a vacuum, with the proper assistance, you can help to push things forward. I'll just give two illustrations, which I may not be able to connect as such. I will just give an illustration from two movies of the past of Insaf Ka Tarazu. That was a case where there was a rape victim and there was no witness. It created an impact and there was an amendment in the rape law. Then there was a movie called as Ye Aag Kab Bujhegi. That was in respect to a dowry case. Then again, there was no witness. There was a development and the precedents, the law was evolved and the sections were modified. So that's what I'm trying to say. Sometimes with your lot of reading, lot of, now I can say during these virtual times, wherever you want to gain knowledge, there's a lot of Google, YouTube, you put it anything across, you'll find a lot of things. And those researches, thought processes do help to develop a law in the right manner. Like I will just give an example. There's a case where Senior Citizen Act is there. There were certain rules made out. A lawyer argued out here that it is not within the domain to do that. That Justice Rana took a different law. He says that law has to be developed in this way. So law sometimes evolves with a lot of research. I can ask Mr. Trivikram now to put his thought process on this aspect.
Okay. Anyway, before Trivikram would take up that for a particular point, I wish to just put forth to Justice Ramon sir. Sir, the other day there was a webinar conducted wherein Brian Pierce was saying that it's always not necessarily be adversarial in nature, and there can be such an argument put forth acceding to the points raised by the other party. And how well would you see when once we are acceding to a particular point raised by the other party at the counsel representing the plaintiff, will it not vitiate your case, and will it be possible for you to convincingly render the points and impress upon the court when you are in a way consensual in nature or accepting a part of the case, and how to proceed further with respect to that, and that aspect kindly dwell upon.
Justice must be done or seem to have been done. That's the whole idea of justice.
Yeah, justice must not only be done, but manifestly seem to have been done. And administrative
if that is the rule of law, and if that is justice, then it doesn't matter. You can always weigh the pros and cons. A judge can always weigh the pros and cons, and then he could decide differently. It is possible. Now, you started all this with something called as a vacuum in law. Of course, Article 142 of the Constitution gives all the powers to the Supreme Court to lay down a law. In fact, if you see, the legal services was one of the brainchild of the Supreme Court, the Legal Services Act. Similarly, 142 can be used by the Supreme Court alone and nobody else. That's one aspect of it. Then the other part of the vacuum as such, if you come to the civil laws, we have custom. There could be customary laws, or there need not be a law at all for it, but then there is a custom. You establish a custom. In India, as all of us know, the idea is that once a daughter is given in marriage, she settles down with the husband. And if the husband stays in the matrimonial home, well then, it's not a right that is given to the wife, but she has some value to stay back in the husband's place. Of course, Bombay High Court has taken a different view. But nevertheless, the fact that she's entitled to stay there, though not be under the statute, nevertheless, there is a custom prevailing where the son brings his wife and stays with his parents. Now, there are many other laws which have come up, new laws, like Vikas was saying. Every time some new situation and circumstance arises, and if the law does not provide for such a situation, there is a change in the law. We have, the law by which the senior citizens are protected. The parents are protected by certain actions of the children. Now, these are laws that will come into force as and when situations, circumstances deserve. So, if you cannot say that there is a vacuum, the vacuum is always filled with a law. But the final thing is justice must be done. How do you show justice in such cases? The case that you mentioned about the lady being thrown out with her son or child by the mother-in-law. Well, justice requires that she's entitled to stay there as long as the son resides with the parents. And if the son dies, assuming the situation, the son dies, where do you think this lady will be? You want to make her a destitute? That's not the law. That is not justice, to make somebody a destitute. Justice is to give her a home to stay. That is justice. So, justice adds all these things to fill up the gaps or the points that are left out in law, the loopholes that are left out in law. So a judge always covers his case by this word justice. That's how I look at it.
Very, very great, sir. And thereby we can rename the courts as not courts of law, but courts of justice.
Yes, it is always courts of justice. It is not courts of law. It is courts.
It should be. And how do you put forth the prayer, sir, in such a situation where there is no law established? And Trivikram, sir, you might put forth as to how to put forth the prayer so that the court of law would transform itself as court of justice.
Definitely. Before that, I would like to touch upon few things that I left earlier. Because the other sections invoked were section 440, 447 deals with punishment for criminal trespass. So here the ingredients have been made out. Though the trespass, there is always a bifurcation under the IPC 446, 447, 448, 449. There are different sections which clearly differentiates. And in the instant case, what we are discussing, there he has been convicted for the offense of 447, that is criminal trespass. Here, why this particular criminal trespass will come into picture is, it was a ladies' compartment. And assumed, it is implied that in a ladies' compartment, the opposite sex is not allowed.
Bolla sir, you are able to hear, sir?
So with that, the honorable court had convicted him, and still I think the defense lawyer could have taken one more defense here, because he was also convicted for section 397, which is robbery or dacoity with the attempt to cause death or grievous hurt. Here, dacoity or robbery will not come into picture, because the other ingredients, when you read the definition of the word robbery or dacoity, those ingredients have not been fulfilled. All right. Maximum what could have been invoked is section 379, that is theft, because he takes away a mobile phone. All right. So there again, I have my own notes, but of course, I have not read the other documents or the evidences, but just reading the judgment of the Honorable Apex Court, what inference I could draw is 397 perhaps could have not been invoked. All right, that is one thing. Yes, sir. Now with the prayer, yes, we always have an alternative prayer, especially before the High Courts and the Supreme Court. We always live it to the wisdom and the discretion of the court, and there is always something called as inherent power. Under 151 CPC, 150 section 151 Civil Procedure Code, it is given. Again, under section 482 of the Criminal Procedure Code, it is given. And always, as lawyers, we always plead and say that under Article 226, the sky is the limit. So always, and the High Courts and mostly these questions will come before the High Court. So the honorable courts are always vested with those the jurisdiction to entertain with the alternative prayer. I hope I am right, my lords.
Yes, certainly.
Yeah. The court may be pleased to give an order if whatever order it deems fit.
Deems fit.
In the interest of justice.
In the interest of justice. That should always be added as a corollary, and may it be treated as a stereotypic prayer. With all this, we come to the end of the session, and if there are some, say Dr. Jayasimha or any other professor would like to raise anything or supplement their views about this, you are welcome, sir.
We would welcome. We will welcome all of them to say something.
Kindly unmute yourself.
Yeah. Respected Honorable Justice Reddy sir, and the two panelists, Trivikram and Vikas. It has been a very scintillating to listen to you all on the aspects of the mooting skills which the students have to develop during their course. Yes, I agree, because me and Bolla, we belong to students of 80s where the mooting was not part of our education, but of the late, now in the present scenario, this has become the very part and parcel of the legal education. And the students who have all participated here must take a lesson from this panel discussion and prepare themselves for the challenges in the legal profession, because 21st century belongs to the legal professions, and we need to develop all these skills of advocacy by looking into the seniors like Justice Mohan Reddy Garu and Trivikram and Vikas. Thank you, Dr. Bolla Mohan Rao. It has been a very pleasant learning for me also, and a pleasant time to spend with you all. Thank you. Good day.
Very kind of
Professor Bolla. Yes. Professor Bolla, just to share an incident in my life as a lawyer, as a student of law. 1976, that was the thick of emergency.
Yes.
And I was in my final year of law.
Oh.
Year of law. There's a 3-year law course. We never had anything called mooting those days.
Okay.
Moot was to go to the court and sit in the court and listen to what was happening in the court. That was the only thing.
Court observation.
Observations. I happened to be present in court hall number 1, presided over by Justice Govind Bhatt, the then CJ of Karnataka, Mysore High Court, Karnataka High Court. And the case was one of nationalization of the buses, transport services in Karnataka. The matter was challenged. The ordinance was challenged. It had come up before Justice Govind Bhatt. And then the then Advocate General was Justice Mr. Baira Reddy. He was the twice Advocate General.
Okay.
Now,
Our Anand
even
Bhaira
before,
Reddy.
yes, Anand Bhaira
Relation
Reddy,
to-
Justice Anand Bhaira Reddy's father.
Oh, yeah.
Yeah.
Bhaira Reddy.
So this gentleman, a short, stout, very confident lawyer, I would say pickable lawyer, excellent lawyer, he stood up, and when the case was called, Justice Goindbad, in his usual form, he said, Mr. Reddy, there's no way this legislation can be, this ordinance can be held valid. That was the opening argument of the opening argument. I'm talking of argument by a judge.
Oh.
You know what Mr. Bhaira Reddy said? And I still recollect it, resounds in my mind. He stood up and said, my lords, walls have ears. Judge did not utter another word. Ultimately, the ordinance was held valid. Just to tell you what kind of stalwarts were there, what kind of lawyers who would instruct the judge. You see, that is the competence of a lawyer. Vikas was saying, how does one get self-confidence? Self-confidence is only when you have a command over the subject. You know what you're saying. If the same statement was made elsewhere, they would have taken it as a contempt of court. And under Article 215, maybe start some contempt proceeding. But that's different. But what I'm saying is, a man of that stature, a twice Advocate General, stands up and says nothing more except to say walls have ears, and that was emergency at that time. All these people were behind bars. And the judges understood him so well, they kept silent all through the proceeding for 2 days. I attended both the days. And then finally, the judgment was the ordinance was held to be valid in law.
Okay.
Yes. So this is exactly what lawyers have to become. So when do you become such a kind of lawyer with confidence? Only from the mooting stage. At least kids have this mooting proposition in courts now. Those days it was not there. So, we went through a struggle. We went through sitting in court hall to understand what was happening, to understand procedures, to understand the nuisance of the court itself, and to understand how arguments were put forth for and against. See, these are things which these children need not have to go through. They can learn in the court, in the colleges.
Yes.
It's like you, like professors.
Kindly repeat, pardon, what was stated by the
Advocate General.
The Advocate General.
He said, walls have ears. Walls have ears.
Okay.
It was emergency.
Yeah.
And he said, walls have ears. The rest is for you to understand whatever you want.
So great. Anyway, so good. And Preeti, are there any queries from the students?
No, sir. I think.
Okay. Then,
sir, if I can interrupt, for a moment.
Please.
I would request you to conduct these kind of webinars even for the rural students. What's happening is the students from the official areas, they are not having opportunities for mooting. Yes. Though it is a part of the syllabi as prescribed by Karnataka State Law University, they are not able to have it in the right fashion or the right manner. Okay. Right. So we are getting good trial lawyers, trial advocates from the rural areas who confine themselves to those areas, and we are having advocates who confine themselves only before the High Court or before the Honorable Supreme Court. So which is not a good sign. So therefore, I request you to extend these kind of opportunities even for the rural students, as colleges like Kristu Jayanti College can definitely extend it to the Mofazal area students. So we will have a good combination of trial advocates as well as good advocates who can appear before the superior courts, as in the High Court as well as the Apex Court. So we will have a good combination of advocates. That is only my request.
Very good point made out, Trivikram sir. Actually,
I think his lordship is also.
I have been sharing this information only among two friends, one known and another unknown, and we are always striving to outreach about the programs, and I take the opportunity to tell you we are very much happy if you have, even if we have 1,000 people or 2,000 people coming to our campus, even in the physical mode when we are organizing, and our management is with the open door mechanism of the disseminating knowledge, and you are all well aware. And for the last 2-3 days, I have been sharing the information in all the possible platforms, including every known platform, and even finding some group in the Facebook, and I have been putting that information about this webinar. And every time we try our level best for the outreach, and my faculty colleagues also do the same, and we are all welcoming all those people, and exclusively when we are thinking of, we are in fact planning to organize a intra-university moot, whereby
Perhaps
all the other law colleges also would sponsor one team from each one of the college, or 1 or 2 teams if possible. And soon after the pandemic, we can think of organizing that, and we take your support also for that matter. And Honorable Justice Mohan Reddy sir, or for that matter, we have n number of judges in the contact list of Vikas Chatrath sir, as well as you, and even Jessima sir's support also. And now I with all this, and if Justice Mohan Reddy sir wants to supplement something as required.
Before we part,
yes. Yes.
Not only for Trivikram and Vikas,
yes,
and all of you in the professors and colleges, one anecdote. In a case before the trial court in a motor vehicle accidents case under the MVC Act for damage, for compensation, it so happened that the person who suffered the injuries, the petitioner, he died. So what happens? Petition gets dismissed. So the lawyers asked me and said, why can't we ask the state government to make an amendment to the law which provides under the Succession Act to bring that provision into the Motor Vehicles Act and permit the legal representatives to continue the case. They pointed out to a provision under the Kerala Motor Vehicles Act.
Okay.
And then we wrote to the central government, and we wrote to the law commission in Karnataka as well as in the center to make that amendment for our state also. I am told so far it has not been done. But if it is done, it's a wonderful piece of social legislation. This is how the changes take place. This is how lawyers help in bringing about these changes as well. This is what I wanted to say.
Very great, sir. Right? It sounds as if we have just be remedium, or whenever there is some right to prove, there should be a remedy, and the courts are expected to be remedial and be as courts of justice rather than courts of law. And with this note, we have a take home a lot of ideas as to how to proceed with a moot proposition, and which are the preparation and involvement in which would definitely develop the networking, confidence, and the research outcome in the form of knowledge, and make the students develop such confidence that they can put forth the argument before any forum, including the Supreme Court. And I take this opportunity to thank from my side and on behalf of the management, and I request Preeti to take forward the session and conclude it.
Thank you so much, sir. Thank you to our chief guest, and to all our panelists for this very informative and engaging session. I'm certain that the students and the participants have greatly benefited from this. Thank you. especially to the respected panelists for reminding our students about the importance of mooting and for illustrating it so well for us. And thank you also to Professor Mohan R. Bolla for moderating the session so efficiently and for also bringing up the nuances of mooting. Now, as we conclude, I would like to request Professor Vani KG, a faculty, Kristu Jayanti College of Law, to deliver the formal vote of thanks.
Thank you, Preeti ma'am. Am I audible?
Yes, yes, ma'am.
Okay. So, very good afternoon, one and all present here. I, Vani, faculty member, Kristu Jayanti College of Law, consider the occasion as an honor and privilege to extend the vote of thanks. On behalf of the Kristu Jayanti College of Law, I extend sincere thanks to our chief guest, Honorable Mr. Justice Ram Mohan Reddy, sir, for taking his precious time and consenting to be the chief guest. Sir, indeed, your words have inspired our students. Thank you, sir, for sharing with us your words of wisdom. Thank you very much. I thank Honorable Mr. Justice P.S. Narayanan, sir, for gracing the occasion. Thank you very much, sir. I must remark a proficient sense of gratefulness to our panelists for sharing with us some of the finest mooting skills and principles of advocacy, and all the participants of this meeting are all inspired by your highly sparkling words. I want to extend my generous thanks to the panelists, Shri Vikas Chatrath, sir, and Shri Trivikram, sir. Thank you very much, sir. I would like to thank our principal, Professor Mohan Rao Bolla, and the moderator of today's program has wonderfully drawn out the points of discussion and conveyed the mooting skills with more clarification to our students. Thank you very much, sir. We have been fortunate to be assisted by our director, Reverend Father Emmanuel PJ. You have been a constant support and you have given us a lot of encouragement. So thank you very much, Father. And I also thank Professor Dr. Jaisima sir for sharing his views and gracing the occasion. And I also thank Dr. Shivkumar, Professor Nageshwar Rao, and all other dignitaries, principals and faculties of various law colleges, advocates for gracing the occasion. And I thank all the participants and students for your patient hearing. I once again thank everyone for making this program successful. Thank you, and I remain.
Professor, very kind of you once again, everyone, the galaxy of friends and advocates, Honorable Justice, and very kind of you. We look forward for similar and even better platforms where there is possible dissemination of knowledge to the wide galaxy of legal fraternity.
Professor, there are 2 questions remaining unanswered. I see in the chat.
Yes, sir. Yes, sir.
Okay.
They need to be answered by all of us.
Yes, please.
One question is, why is there always a delay in judgment when it comes to rape cases? Is it because there is lack of evidence, or is something else happening behind the screen? Now that is calling for some kind of a comment. Okay, there is a delay. We do understand various things like prosecution not bringing the witnesses, or witnesses not being available for the prosecution at that point of time, or there is large pendency of matters in a particular court. So many various reasons that could be attributed. But to say that there is something else happening behind the screen, I think it is unnecessary. It is more like, a rhetoric given by a TV journalist.
Okay, yeah, that's
fair. Not agree to anything happening behind the screen. Then there's a second question. Sir, in this pandemic situation, people have died without giving proper treatment and oxygen, and government not accepting its mistake. Can our judiciary do something about this? We can do something about this if somebody comes before the court for case of damages under torts. Certainly you can file. You can claim. I'm sure Trivikram knows better.
Yes.
As a lawyer, he could initiate of filing a case against the state of Karnataka. It's on behalf of all those who have died, all those who have suffered in the pandemic, all those who did not get all these benefits. It's a comprehensive case for damages which can be filed. I'm sure if the thought process of the lawyers start working, they can come to the rescue of all these people. This is my answer to this
Yeah.
second.
If
Very
I can
great.
only
And
add to this,
I
my lord.
appreciate Jerome Benz and Rudresha for raising such questions. And now Trivikram is ready to, with that enthusiasm, to file a PIL for the constitutional tort that has been committed with respect to these victims of these pandemic and the unavailability of oxygen. And there have been oxygen deaths or lack of oxygen deaths. Please.
Sir, just to add on to this, both the cases are pending before the Honorable High Court. The cases, the public interest litigation, as well as the suo moto case registered by the Honorable High Court, which is pending before the Court Hall 1. So I would request those students to log in as per the SOP. They are, I think, permitted to log in. So they can also be a part of the, I mean, they can, as it is by virtue of video conferencing, they'll be able to watch the proceedings. So I would request them. And the first question is, as my lords correctly mentioned, nothing happen behind the screens. The only reason the delay is, say, what happens if what we saw in other states like UP, there was an encounter. We wouldn't be knowing if the accused is the same person who has committed the alleged offense. All right. So there should always, we cannot hastily decide the case. It should go in the right way. It should take few, I don't say there should be an inordinate delay, but the delay is only because the prosecution or the investigating agency should come out with the final report that has to be placed before the court. The right trial has to happen. In cases like Ajmal Kasab, our courts, you know, the entire world has appreciated our judicial system, where the right way he was convicted, all the rights conferred to an ordinary citizen of this country was also extended to some other, citizen of some other nation. In such being the, state, and realizing the importance of individual rights, it cannot happen overnight. So our courts have been very, it is going in the right pace. I understand that as a student, you will be more inquisitive that, justice has to be given overnight. That can't happen, especially in heinous offenses.
Yes, indeed. Vikas sir, very kind of you. And if you want to supplementary views.
Oh, I would like to only add that, in fact, if we find that throughout majority of the states in different high courts, including the Supreme Court on pandemic, a lot of directions have been issued. And if you remember this Madras High Court judgment, which has created a lot of hue from the Election Commission, and then further development of law by Justice Chandrachud, saying therein that you can't just silent everyone. The expressions, the oral expressions are also part of this. Well, we are talking about live streaming of the cases to be come across. How can you do? There is all involvement what we have been discussing with the moots, and like the first question came, any other writ or direction. There have been these where we find pan India in different states, in different high courts, wherein the courts have taken suo moto cognizance. Our high court has taken suo moto cognizance. They have appointed amicus. Amicus is only a friend of the court. Where we were taking about how to take about things forward. Here is a particular case where the courts takes suo moto cognizance. There is no lawyer representation. Courts appoints an amicus curiae. What that means is a friend of the court, meaning thereby dispassionate about his feelings for a particular case, this way or that way. Because normally every lawyer or a judge tends to come across with a mindset from which what we say in the jurisprudence that it evolves with time. But as an amicus, he has to assist in the right formulation of the law, dispassionately about his feelings for that particular case, and help to settle a law. So in that pandemic, yes, things are improving, and you are finding that the spikes which were there around a month ago after the court's intervention and government also taking initiative in those directions, the right balance being maintained, there is a positiveness. As they say, with a parting, we can say that a famous couplet it says, "Koi raat itni sangeen nahi jiski subah rangeen na ho." That there cannot be any night which cannot have a sunrise in the morning. So we always have the hope, even from the judiciary, law, and the life best.
Okay.
Before parting, I can always say what we all say on a Beyond Law CLC: keep on wearing your masks, maintain social distancing, and get your vaccination. These all issues will automatically be resolved if we maintain ourselves in the right way. Everyone can contribute in his own way for the betterment of the society. Everyone stay blessed. And it is an honor to be on the platform of Kristu Jayanti College of Law. And it was a pleasure hearing, like you rightly said, Mr. Trivikram. I heard Justice Ram Reddy on his insights. We have been reading his judgments. It was always a treat, but they say that the visual treat and the treat for the ears is always different. A good orator also rings good bells in the mind as well as in the heart. Thank you everyone for all those participants who have been hearing us.
Ending with a silver lining by Vikas Chatrath sir, and we request all the students and all the well-wishers here to be safe, and we'll have opportunities to meet and disseminate and share ideas, knowledge. Thank you. Thank you very much. Thank you.
Sir, thank you very much. Just a reminder to the participants to kindly fill the feedback form. A link has been put on the chat box, so kindly do that. Now, I also request all the participants to remain attentive as the Jayanti anthem will now be played.
Yes, okay. And before that, and yeah, Trivikram sir.
Golden disk, sun in the rising east, lights up a life divine, fills knowledge in our minds. Laurels and the book make us sublime. With the mighty Lord, we soar high on the bedrock of faith. Joy and peace, sprawl our hearts and minds. On we march our goals as a beacon for the world, with a passion for our growth and a love for humankind, united and strong in excellence on the bedrock of faith.
Thank you one and all. Thank you very much. And Nilanjan Day is seen. Very kind of you, Vikas sir and Trivikram sir.
Thank you, sir. Thank you for
this pleasure connecting. Joining in the college is always
we go forward together in all our endeavor to disseminate knowledge, and there can be common platforms as we did even earlier, and now onwards we are always together.
Definitely. Once again, my many thanks to you,
Thank
and
you.
all other faculty members who have logged in.
Thank you very much.
Thank you to
Mr.
everyone.
Shivkumar, Professor Preeti, and all other my beloved students.
Thank you. Thank you.
Thank you, everyone. Namaskar. Jai Hind.
Namaskar. Namaskar. Jai Hind.
Amir sir, you can end the meeting, sir.
Yes, please.